this committee has heard this bill before, many times, actually, several times. I will pass out materials that may look familiar to you, because this is what I passed out in prior years. So you're running Ken Wesley's the only one who has not heard this bill before. This is what I affectionately call Tyler's Law. This is, the front page is a copy of Tyler Strong and Mr. Russell. This bill has had many, many advocates. The only reason I'm not bringing them all back is because I think all of you have heard the arguments before. The heart of what this bill does is it says a court must consider child abuse and domestic violence when it comes to custody decisions. And in the package which I've submitted to you are a number of letters from various lawyers throughout the Commonwealth. I'll just give you the highlights of them. The first is from a lawyer in Chesterfield, Virginia. That's Mandy Wilson. She writes she had a custody case where dad had previously been convicted for beating a pregnant woman, had served a year in prison. Mom never knew this, and he beat her while she was pregnant. Then mom found out, tried to bring it in. The judge would not allow in the prior conviction of domestic violence because the code says it has to be part of the family or household. The next thing I've submitted is from Tyler Strong, the young man in the picture. And he talks about the horrific nature of the abuse he suffered from his father. I think many of you remember him coming in last year, the year before. He talked about how his father abused him and told him not to say anything, and told him to lie to everyone, and why he kept the abuse away from his mom, because he was afraid his father would harm him even more if he told anyone. In Misty Russell's case, Tyler Strong's case, there were prior examples of harm that this man had done both to women and to children. Actually, there's a new addition this year. This says the handwritten stuff near the back, and it shows that in 2012 there was a criminal complaint sworn where he harmed a different woman, smacked her in the face. She fell to the ground. When I got to my feet and tried to pass him to get her daughter, he pushed me, grabbed my arm, shook me, ripped my shirt from me. When I tried to get away, smacked me in the face a few more times. He kept coming at me, and then locked my car and took my keys and hid. The next is actually even worse. This is how he threw an infant downstairs, cracked his skull. And all of this was not allowed in by the court because the current code section says it has to occur within the family and household, and these all occurred outside the family and household. On the last page is a new statement, January 21st, dated today, by Tyler Strong. You can read in his own words the suffering that he underwent and why nothing happened, frankly, until his father threatened to kill him, and then he finally went to his mom. But he suffered for many, many years. His mom tried to bring this past incident with other women in, and the court said, nope, not one of the factors, we're not going to consider it. There's another letter. This letter is from Lauren Cottle. She's an attorney in Henrico, and talks about she's been doing this for 27 and a half years and believes that other abuse needs to be considered, and that many people appear in the court without the benefit of legal representation. And if so, the court just goes down the statutory factors, and of course the statutory factors don't include abuse that occurs outside the family. The next letter is from Randall Eads. He's an attorney in Abingdon, Virginia, and he writes, I've often seen instances where an issue of abuse which is not involved the children of the case at hand may not be given appropriate weight by the court. Lastly, another lawyer, Bryce Lambert, he's a lawyer in Richmond, practiced in Virginia for 20 years, wants to see this added to the factors. So last year, we had all the parties agreed on language. It's actually the language that is in Delegate Collins' bill. That bill is HB 1653. The heart of the change that both he and I have provided is in the factors, which says that in the factors, you should look at not just family abuse, but domestic abuse and child abuse, in addition to sexual abuse. And then the question is only how domestic abuse is defined. That's actually the only difference between Delegate Collins' bill and my own. As I said, I support his bill, he supports my bill. There's two different ways to go about it. His bill is actually my bill last year, and his bill talks about domestic violence as, this is line 103 of HB 1653, a pattern of abusive behavior in any relationship that is used by one partner to gain or maintain power and control of another intimate partner. Domestic abuse includes physical, sexual, emotional, economic, or psychological actions or threats of actions that influence another person in any behaviors that intimidate, manipulate, humiliate, isolate, frighten, terrorize, coerce, threaten, blame, hurt, injure, or wound someone. And that's the language that the vast majority of members of this committee voted for last year. The Family Law Coalition and the Sexual Alliance and all came in support of. They did talk to me this year, and they felt that a narrower definition was a better definition. So in my bill, HB 2650, is a narrow definition, like 102, 103. Domestic abuse means a pattern of abusive behavior in any intimate partner relationship, whether or not directed toward a family or household member. And that may be a simpler solution. I am ambivalent as to which solution. I think it's vital that we include domestic violence. How we define it, I really leave up to this committee, whether it's a Delegate Collins bill or my own. But I firmly believe that these cases have to be taken into consideration because, let's face it, when someone is abusive toward intimate partners, they're very likely a danger to children. We've seen all these examples, and I hope this bill will go forward. Happy to answer any questions.
Does any member of the committee have any questions for Delegate Levine? Anyone else in the audience wish to speak in favor of the bill?
My name is Isaiah, and I actually prefer the language of this. I was originally going to speak for 1653. Again, I'm a father of two in Forest, Virginia. I'm really grateful that, again, that this committee is looking into family issues. I think it's incredibly important. I really think this bill is a really great start, and I think this is going to be, what would make a solid bill with either of these would be addressing what Congress did in a joint resolution in last year's Congress, HR 72, that would require those trained to diagnose and review family and domestic abuse issues. The language as it is, I think, would kind of give judges and guardian ad litem and those folks kind of more of an idea of making almost like a psychological determination whether they're focusing on law. I think what would help in these issues is having trained professionals review these matters, and I think that would be really significant gain for Virginia families, and of course, to be putting children's safety first, and I think that's something that everybody wants. My mom used to take in families who were going through these situations. I've seen this firsthand. So either way, I think the language in this bill is fantastic. And again, I want to thank the body for considering this and for your purpose. Thank you.
Thank you. Anyone else wish to speak in favor of the bill? Anyone opposed to the legislation?
Yeah, Mr. Chairman, Richard Gary, Virginia Bar Association, Family Law Coalition. I'm not really opposed to the concept of the bill. What's occurred since last year and this year, working with both Delegates Levine and Collins, we have been in contact with both the OES, the Virginia Poverty Law Center, and the domestic violence advocates here in Virginia. And we're trying to get a consensus on the definition of domestic violence. The definition that one of the bills, I think it may have been Delegate Levine's bill last year, is basically the definition that the American Academy of Matrimonial Lawyers Domestic Violence Task Force, of which I've served in the past, came to nationally. But there's some disagreement on how things would work. What we had, and I'm not, quite frankly, I'm not sure if we were able to get to Delegate Collins or not, but we had a discussion late Friday evening about how to deal with this. And basically, in speaking with the other stakeholders, we were going to come and ask Delegate Collins. We assumed the Delegate Levine's bill would be rolled into Delegate Collins. We were going to ask that it be laid on the table so we can do a joint study with these other groups and be able to come back to the General Assembly with a definition of domestic violence that all the stakeholders could agree on. And that's really our position to build this.
Thank you, Mr. Chair. Any questions for the committee?
Go ahead. This is Sheila Vargas. working on behalf of the Virginia Poverty Law Center. We've been working with Delegate Collins and with Delegate Levine and all the stakeholders as well. I think the thing that I recognize Delegate Levine wanted to address from these past several years is the issue of child abuse, basically, that's not against a family or household member's child, right, or a family or a household member. So I am very supportive of that child abuse or language in this bill, but I would like to take some time. I think it is very important to expand the definition of what is family abuse or what is intimate partner violence. I'd like to take some time and hold off on that to get a definition that works for the entire code, not just the best interest of the child factors. Thank you.
Sir.
Mr. Chairman, David Westhoff with the Family Foundation. I just want to echo what the previous speaker said. We're not opposed to the concept of the bill, but we're rather really don't understand really what the definition of domestic violence is, and for this reason, this is why we oppose it.
It seems to me what we're kind of doing on the surface here is redefining the laws of evidence and what prior bad act means and how it's relevant to a current custody proceeding. And I tend to agree with those who like to try to refine the definition.
So, Mr. Chairman, here's I guess my problem with that. This is the fourth year we've brought this bill forward. I reached out to the Family Law Bar in 2016, in 2017, and 2018. At all times, they have refused to discuss this. They made it clear they don't want domestic violence in the code. They don't think it's an important issue. And I've been very disappointed by the reaction, including the fact that this year I contacted them in April, June, September, October, telling them we don't value last minute changes. It is true. They also, should be noted, came here, stood at this podium last year, and testified in favor of the long definition, which is definition in Delegate Collins' bill, which is the federal definition. And again, I'm fine with that. But to the extent that that seems to go too far to people, I think the definition in the bill that I've provided, 2650, really is very simple, and it would allow a court to look at the case, and it just simply says domestic abuse means a pattern, so it can't just be one, a pattern of abusive behavior in any intimate partner relationship, whether or not directed to a family or household member. And to me, this is a pretty clear definition. It's not as long and as the other one. And frankly, this is the one that I think if you'll talk with some of the people who just spoke, they may not like either one, but they certainly like this one better than Delegate Collins' bill. Again, I'm happy with either one. But to go another year with another study that I don't think is going to happen, because it hasn't happened in the past, even though I've reached out to them consistently, I think is really, you all have heard this bill many, many, many times. So I think we go forward, and let's go ahead and approve 2650 if Delegate Collins wants to, can argue his bill. Either one, but I think it's time to go forward today. We've been through this many, many years, many, many times, and again, domestic abuse means a pattern of abusive behavior in any intimate partner relationship. To me, that's as simple and obvious a definition as you can get, and actually comes very close to one of our earlier definitions that Delegate Kogar and I worked out together, other abuse. So I think that's the simpler one, and then if we want a more complex one, I am more than happy to work with all the stakeholders and improve this next year, but I think we should go forward as we are. Thank you, Mr. Chairman.
Okay. I need to present a bill in appropriations. I'm going to pass it down to my colleague, Delegate Kilgore, in a minute here. But a question for Mr. Gary. Who would be the appropriate, if the committee wanted to have this definition studied and refined, who would be the appropriate body to do that?
Judge, I think in our discussions Friday.
Not yet. I'm not a judge yet.
I'm sorry. It's all about.
Mr. Chairman of the subcommittee.
Mr. Chairman.
Yes,
You get the podium. I think in our discussions, and Mr. Gray will tell me to sit down very quickly if I'm volunteering folks for something we haven't. In our discussion with the coalition Friday evening, I think it was our anticipation we would welcome heading up that study and talk to OES and Virginia Poverty Law Center as far as coming up with a committee that can put a definition together. And I think a letter from either yourself or the chairman of the full committee would put that into effect immediately.
Quick question for Levine.
Yeah.
Levine, Levine, having heard that representation, do you wish to go forward on the bill?
Yes, I do. I'm sorry, look,
Well, so the reason I ask is that if we had an agreement, then I could probably finish that up, but, I've got to run. There's only one other person for me to present.
I mean, I'd be willing to wait a week or something, but I'm not willing to let the bill go by this year.
I was hoping we could find common ground. If not-
My problem is that honestly, the representations, we've tried to work with them and they have not been willing to work.
So
With either Delegate
what we're going to do
Collins
right now is I'm going to pass the gavel to Delegate Kilgore. He's going to run the meeting. I think when I leave, we're going to lose the quorum. So when our members comes back, we can finish up. That's the point I was trying to make.
Fair enough, I can wait for the quorum, or we could take a vote now, whatever the chairman will.
Well, I didn't want to cut your argument off. I mean, if you have more you want to say, or the committee has questions, I'm happy to let it go forward. I don't want you to feel like I'm running out, so.
No, I'm ready, hopefully we can move forward today. I don't know what the pleasure of the committee is.
What is the pleasure of the committee?
Mr. Chairman, question, what is the status of Delegate Collins?
He's presented a bill, Crum sub one, he's the only two bills we got
What's
left.
his plan to pass it by?
I think he was going to table his bill
Oh, is that right?
and allow folks to take a look at it and also.
I see. Thank you, Mr. Chairman.
Got a motion?
Move to report.
Second.
So motion to record and a second. All members, please cast your vote on the board. Motion carries. Bill reports number 3-2.
Thank you, Mr. Chairman, members of the committee.
And let me say, what I want to do is y'all try to work this out, this definition out between now and so I'll let you know if there's a definitional problem, try to work it out. This won't come up for a while, another week probably.
Well, and because there's a no vote, it will go on to the full course tested docket, which won't be probably until the next
It'll be
Monday.
Monday. So you got time to do it.
I'm willing to work with them if they're willing to work with me. Thank you.
Thank you.
Mr. Chairman, members of the committee.
So, this is going to be a recess for a little bit.